So thank you again so much. Welcome back to the CLE Symposium, Racial Justice, Restoration and Inclusion, Human Rights Principles and Local Practice. And we are going to launch into our first panel discussion, Foundational Concept of Remedies and Reparations for Racial Injustice from Global and National Practice. But before that, I just wanted to remind folks who are just joining that you'll be able to submit questions using the Zoom Q&A function. For those of you seeking CLE credit, reminder to listen to the course codes. You will need to add those to the verification form. And for Twitter for today's event, you can use hashtag CLE Race and Rights. So it's really my pleasure now to turn it over to Nadia Ben Youssef, Advocacy Director at the Center for Constitutional Rights, for a global, national, and local tour de force on some of the key concepts raised by Margaret in the morning keynote. Thank you.
Thanks so much, Joanne. It's a pleasure to be here and an honor to be a part of this event. CCR is so happy to sponsor and to support the work of the Human Rights Institute and to be in partnership for this annual CLE. So it's great to be here. I want to first start my remarks by just acknowledging that I'm calling here from Harlem, New York, on the land of the Lenape people in the island of Manhattan. And as we talk about reparations and we talk about historical justice, to recognize that we and many of us are calling in from stolen land is a key framework and a position that we have to take very seriously as we engage in these discussions. So I would encourage us all, and particularly on May Day when we are honoring resistance and we are celebrating the victories of human rights and we're thinking together about what does reparations mean, what does remedy mean, we honor the people who are setting forth key demands about decolonization in this settler colonial space in which I inhabit, calling you here from the United States, Turtle Island. I am so thrilled about this panel because so much of the challenges of human rights, which I think all of us recognize as really illustrating the emancipatory potential of international law, is often a disappointment. And Judge Burnham spoke about it. I think you have already attendees who are asking, how do we make this applicable? How does it matter? Particularly in the United States, but elsewhere. And what's exciting, and I think we'll get to a bit in the panel, is human rights and the power of human rights may not lie in the law itself, but rather how we make it matter. How do social movements make this matter? How can human rights bodies become vehicles for resistance? So it's an exciting time to think together about how to make human rights matter and encourage you to ask questions of our panelists. This panel will explore global examples and local domestic examples in the United States. The panelists will introduce core concepts and offer concrete ways to operationalize them. So we're going to identify ways that human rights can be used in advocacy, and we're going to see how lawyers can use these tools, how social movements are using and making these tools matter. We're going to talk about terms like truth and reconciliation. We're going to dive into the right to remedy and reparations. And so really grateful also for Judge Burnham to challenge us a bit and critique it. And I think we'll have a little bit of a chance to do that as well. So I will start by introducing our panelists and then we'll dive right into the presentation. So we are joined today by Ruben Carranza, and you'll have the bios, the full bios available to you. But Ruben is the senior expert and director of the Reparative Justice Program at the International Center for Transitional Justice. We are also joined by Wade Henderson, who is the former president of the Leadership Conference on Civil and Human Rights. And obviously bringing in a wealth of experience, and I encourage you to look at these bios because they're pretty tremendous. Also joined by Justin Hansford, Associate Professor of Law and Executive Director of the new Thurgood Marshall Civil Rights Center at Howard Law School, leading scholar and activist, friend, and also board member of the Center for Constitutional Rights. We're glad to have you, Justin. and Monifa Bandele, who is a brilliant political strategist and thinker, wears many hats, is the senior vice president for Moms Rising, and is joining us today as a member of the Movement for Black Lives Policy Table, which last summer released the Reparations Toolkit. So you are in for a pretty tremendous panel, and really looking forward to lessons learned. And I think we'll dive right in. So I'm going to start globally and then move to local examples. And so we're going to start with you, Ruben, and going to see if you can introduce us to some of the core human rights principles that animate your global work. So to advance remedies and reparations. So looking to you for a bit of an introduction. So at the end of this, all panelists, all participants will have kind of the framework, as Joanne was mentioning, that'll get us thinking together about how we operationalize. So Ruben, I'll turn it over to you.
Thank you. And I'm glad to be here virtually. The topic lends itself to various approaches, and I'm happy as well that we're incorporating a global perspective. One of the things that I thought is important for any discussion on racial injustice and reparations in the United States is to look outside and not just inside. And so I'm here to try to compress what I have to say in a few minutes. I usually teach this as a class at NYU for one semester, so this is going to be challenging, but I'll get right to it. I'll open my slides so you can see, and let me just, so one of the aspects that I want to focus on is operationalizing remedies and reparations in the work we do in ICTJ, the International Center for Transitional Justice. I usually mention the fact that whenever we do workshops, especially in other countries, that what we're really talking about is justice and not transitional justice. In our workshops, nobody, when you ask victims of human rights violations, for example, what they want, nobody comes forward and says, we want transitional justice. They say, we want justice. But in the United States, transitional justice, as Margaret mentioned earlier, is both a difficult concept to grasp, and often is also seen as a foreign concept to look at. So here's a quote from former President Obama. When he said this, he was talking about accountability for torture during the Bush administration. And so one question I will ask participants to think about is whether this suggests to us.
Ruben, this is Nadia. We don't see your slides actually, so can you share screen?
Oh, sorry.
On the bottom.
I should have, yeah. There you go. Okay. Do you see it now?
Great, thank you.
All right. So this is a quote from former President Barack Obama. And one question that comes out of this statement is whether he was against accountability or is against accountability. When he went to Argentina a few years later, he seems to be for accountability, expressing regret for US policy during the dirty war in Argentina and therefore supporting transitional justice processes that are still going on in Argentina. So here's a quick rundown of compensation as justice. I will go back to this and distinguish this and in a way talk about the overlap between this and reparations more generally. So since I mentioned Argentina, in Argentina, after the military junta fell from power, there was a process of transitional justice that is still going on. And one of the processes includes reparations. And so as an example, families of the disappeared received about 200,000 each for the disappearance of their family member. Take note that the 200,000 was given to them in bonds, in redeemable bonds, redeemable in 15 years from the time they were given to them. One footnote that's important here is when the bonds did mature, Argentina's economy had fallen so low that the bonds were almost worthless. South Africa also has had a compensation program giving about $3,000 or $4,000 to 23,000 apartheid victims who registered at the Truth and Reconciliation Commission. So a note to make here is that obviously there are more than 23,000 victims of apartheid in South Africa, so that this was really a very limited compensation program. In the Philippines, just 2 years ago, they completed a reparations program for victims of the Marcos dictatorship. Part of the program was funded by assets recovered from the Marcos family in Switzerland. So $680 million was recovered. 200 million of that was used to pay compensation to 11,000 victims. And in Kenya, a few years ago, and ICTJ played a little role in this, victims of the colonial torture committed by the United Kingdom were paid about $4,500 each. 5,000 veterans of the Mau Mau Land and Freedom Army were paid. Now, this is all compensation. And we might tend to think that this is all that was given, but in each of these examples, memorialization happened. In many of these examples, except for the Philippines, a truth commission was established. In most of these examples, except for Kenya, criminal prosecutions took place. So there's a set of transitional justice remedies that happen more than just compensation as a form of justice. You have truth commissions, reparations programs, prosecutions, and institutional reforms, which is meant to be the never again component of transitional justice. So one question that participants may want to think about is reconciliation. Where does it fit in? We've heard mention of the South Africa Truth and Reconciliation Commission. Are all truth commissions mandated to pursue reconciliation? The quick answer is no. And there have been truth commissions, in fact, in the United States. One of them, again, ICTJ was supportive of this, was the Greensboro Truth Commission. And another one, less prominent, was the Maine Truth Commission to tell the story of forced assimilation of Wabanaki children in Maine. And perhaps one thing to think about when it comes to Truth Commission, truth-seeking and accountability for deaths in the pandemic, it might be useful to point out that after the so-called Spanish flu, New Zealand created an influenza epidemic commission to examine accountability for, at that time, the deaths that took place in New Zealand. And one of the findings was that the graves of victims of the pandemic are monuments of incompetence to the government at that time. So there's an example to examine there. This might sound controversial to some, but in China, they recently organized a national day of mourning for victims of the pandemic led by the state. So aside from truth commissions and memorialization, you have prosecutions, and I won't go deep into this, but domestic and international prosecutions are complementary in the framework of prosecutions for human rights violations, genocide, war crimes, and crimes against humanity. They complement each other. And that's the key, one of the key components of the ICC, International Criminal Court Treaty, for example. So this is how these components work: truth-seeking, prosecutions, reparations, institutional reforms. They combine, at least in the concept of it, as a way of pursuing justice. In 2005, the United Nations General Assembly approved a resolution that we now call the United Nations Basic Principles on the Right to Remedy and Reparations for victims of gross violations of human rights and serious violations of international humanitarian law. So these basic principles propose three general statements: that victims must have equal and effective access to justice. They must have adequate, effective, and prompt reparation. And this is often neglected, but they must have access to relevant information concerning the violations that happen to them and the reparations mechanisms that they can avail of. So what's important, and now discussing reparations more generally, it's important to remember that reparations is a right of victims. It's not charity, it's not insurance, it's not simply tort law being implemented in a legal jurisdiction. It certainly isn't just the benevolence of a government or of perpetrators of human rights abuse. It's a right. It's not just compensation, and this is often the most misunderstood aspect of reparations, so that debates become debates about how much and what we can afford. Reparations can include symbolic forms of reparations, and they can include other material benefits. They can be given to individuals or collectives, including communities or groups. And some of the other questions that are important to ask when we talk about reparations: should it be restitutio in integrum? And many of the lawyers in this discussion will often assume that this principle of restoring the victim back to where he or she was before the violations is a key principle. To me, in practice, it's not. It's impossible. You cannot untorture a victim. You cannot erase the experience of rape during conflict. You cannot bring back a dead person or a person who has been disappeared and long gone. So the goals are really to acknowledge the violation, to give the beneficiary a means of recovering and to live with dignity. And one question again for participants is whether we should set as a goal the transformation of the victim's social and economic circumstances. So in Tunisia, as an example of that, a Truth and Dignity Commission was established after the Arab Spring. And this is a monument built in the municipality where Mohamed Bouazizi, who set himself on fire in 2011 and led to the Arab Spring. I took a picture, so it's crappy. Also, aside from the Truth and Dignity Commission in Tunisia, they now have a Dignity Fund, which is a reparations fund for those victims. Other examples of material reparations, I mentioned South Africa's compensation payments, which are paid as a lump sum. Chile, after Pinochet, established a comprehensive healthcare program. In Sierra Leone, they provided fistula surgery for victims of rape during the conflict. But you might also ask whether victims can reject these offers of compensation, and that has happened. Some of the mothers of the disappeared in Argentina refused to accept compensation. Some of the comfort women victims of sexual slavery by Japan in World War II also refused to accept payment. I'll skip some of the symbolic forms of reparation so that we can spend more time. These are pictures of some of the memorials. This is in Liberia, a memorial which is also a water pump. And I think that's important to remember, that memorials shouldn't just be static images, but should have some functional aspect to them if possible. In the United States, we've seen reparations and apologies to Japanese Americans for World War II concentration camps, for example. This is the apology of President Bush to Japanese Americans, much given years later. Just a final set of slides. In designing reparations, it's important to consult. So Kulumani, which is a apartheid survivors group in South Africa, makes it clear that there should be nothing about us without us. Timing and sequencing matter. There can't be justice without truth, reparations, accountability, but which do you do first? And that's an important question to ask. Funding is important, and it's important to ask whose money is being given. And like I said earlier, transformative reparations may also be considered for marginalized victims. I'll skip these and go to this last two slides. This is a quote from Te-Nehisi Quotes, A Case for Reparations. He proposes, as many of us have read, that there can be a discussion about reparations, even if no specific answers might be produced. But I think it's important not just to ask whether reparations should be given, but to start discussing how it should be given. It's going to be difficult, but you can't proceed without that difficulty. So these are the references I mentioned. And oh, this is the statue of Kunta Kinte in Annapolis. I actually went to the island where Kunta Kinte was taken in the Gambia, where there's also a Truth Commission right now, and ICTJ does work. But let me stop there.
Ruben, thank you so much. You did it. It's a 1 semester course in 7 minutes. So we appreciate you and learned so much. You know, we'll return to some of the examples and we'll dive a little bit deeper. I'm curious to hear you say a bit more about, you know, justice, or you said at least the concept of it. So what do we mean when we say justice with a capital J? And, you know, I appreciate you transitioning us into a discussion of how do we operationalize this? So what's great about the human rights community, a movement for justice and accountability and equality and dignity, is that we don't ask whether reparations are owed. We know that they are, and we challenge each other about how we're going to get there. Reparations are a right, reparations are owed. We're going to get into the local examples now, and I'm going to turn to Wade Henderson. And actually this question is for all of the panelists that will follow, Wade, Justin, and Monifa, which is how and what does the human rights framework offer to your racial justice work in the United States? So we're taking kind of the framework that Ruben set for us, and now we're bringing it home, as Joanne said, and I'm interested in the work that you're doing, Wade. And so if you can lead us a little bit and to explain how you're operationalizing human rights, how you're using it, how you depend on it, how you're challenging it, turn it over to you. Thank you.
Unmute now, okay. Can you hear me? Great. Nadia, thank you very much for that introduction. I am incredibly honored to be a part of this program. And I want to thank the Columbia Human Rights Institute and our friend Joanne Kamath Ward for this incredible concept of a virtual human rights continuing legal education program. I'm especially appreciative of the work of my colleagues at the Leadership Conference on Civil and Human Rights, who have made a deep commitment to engaging in the work that we're going to discuss today. Lastly, I want to thank my dear friend Margaret Burnham for her thoughtful and provocative remarks. Always good to be with Margaret and this distinguished panel that is part of today's program. I'm going to discuss the human rights concept and its application at the federal level, because that is where my experience is most relevant. And one of the points that I would underscore in your introduction, Nadia, is that I'm probably the only person who is part of this program who has had personal experience in the context of the Civil Liberties Act of 1988, also known as the Japanese American Redress Bill. I was a lawyer for the American Civil Liberties Union in its Washington Legislative Office and had a chance to work directly on the passage and implementation of that historic law. And so at an appropriate time, I'm going to elaborate a bit more on that issue. I want to begin in setting the context for how our Constitution and our Congress view the concept of reparations. And I'm going to begin with one of those Roman maxims that we learn in law school, but is especially relevant here. And that is ubi jus ibi remedium. And I'll repeat that, ubi jus ibi remedium. For every wrong, there is a remedy, or more literally, there is no wrong without a remedy. It is a maxim that has found its way into common law and also into the chancery courts of this country. It establishes this principle that equity is an incredibly important part of our constitutional obligation and the rights of those who may have been injured. And it's embodied in part in Section 5 of the 14th Amendment of the Constitution, ratified, I guess, 152 years ago, establishing a basis for providing not only citizenship and the rights pertaining thereto to African Americans, but also to others who have been injured. Now, from our American democracy, there are arguably two original sins. One is the genocide directed against Native peoples in this country, and the difficulty that has been a huge element of what we have had to deal with. The second, of course, is slavery, which is recognized by many as our original sin. And last year, our nation commemorated the 400th anniversary of the enslavement of African people here in the United States. The legacies of enslavement and historical systems of racism, discrimination, and inequality that were born out of that period continue to impact African Americans in every aspect of life. Now, whether it is educational outcomes, economic security, health, the criminal legal system, or voting rights, African Americans are disproportionately impacted by each of these systems. And the COVID-19 global pandemic has only amplified and further cemented what we have known for decades, which is that slavery, wherever it occurs or has occurred, beget racial and economic inequality that persistently plagues people of African descent around the world. And there is an urgent need to provide a remedy to address these historic and present injustices. And in that regard, I want to commend the United Nations for establishing the International Decade of People of African Descent, which has shown a light on that inequality. Now, on the screen, you have a graphic which really focuses on an experience which has been much in the news these past few months, and that is COVID-19's ravaging of the African American community at such a devastating level, ravaging the African American community. What you see here is a tree which gives you a sense of how inequality has operated against African Americans. And you can see the branches of housing discrimination, mass incarceration, high poverty rates, a lack of access to health care, education disparities, barriers to, barriers to other forms of equality, and the various roots that flow from there and the branches that flow from there. And I want you to take note of that because it's an easy way to understand why COVID-19 and the disparities which have been highlighted by that underscore the impact of enslavement and discrimination on African American people going forward. I should mention, I did not bring news clippings that talked about the extraordinary rate of infection and death, whether it is in Georgia or Detroit or New Orleans or New York. African Americans and Latino Americans, or Latinos in general, have been exposed to a level of disease because of their economic inequality, often serving as frontline troops in the battle against the disease or in carrying out basic services for the American people. And ultimately, when this is behind us, there will be a reckoning of how the current system has exploited the inequality of the postures of African Americans and Latinos in ways that deserve to be addressed, and reparations may well be the construct in which we examine these issues. Now, since 1989, then Representative, subsequently Chairman of the House Judiciary Committee, Congressman John Conyers, had introduced important congressional legislation to establish mechanisms to address national atonement for slavery and provide research into reparations. Today, Representative Sheila Jackson Lee of Houston has continued this effort with the reintroduction of H.R. 40, which is the Reparations Commission study bill in the 116th Congress. Now, H.R. 40 would establish a commission to provide research on the effects of slavery and the need for reparations for African Americans. And Nadia, I agree with you that we really don't need to establish, quote, the need for reparations, but nonetheless, this is an important step in the direction of getting legislative intervention by Congress. Now, the bill underscores the importance of the federal government's commitment to upholding constitutional rights of African Americans by at least attempting to better understand the consequences of rampant injustice suffered by Black people throughout enslavement and the subsequent periods of history. And this historical mistreatment and structural inequality persists today. For the purposes of this conversation, I'd like to stipulate among the participants that we have ample indication of discrimination and racial bias in the four primary periods of African American experience in this country. That is enslavement, Reconstruction, Jim Crow separate but equal analysis, and the modern civil rights era, all of which establish without question that discrimination exists. I'll give just a couple of examples and then we'll move on. Let's start with the Equal Justice Initiative's Museum to Slavery that Brian Stevenson and his colleagues have put together, which document the over 5,000 lynchings, the extrajudicial killings that have taken place since, for the most part, the end of the Civil War until the modern day. Plessy versus Ferguson, the Supreme Court's decision instituting a separate but equal in the most devastating of manners. The Wilmington, North Carolina massacre of 1898, which really set a new standard for the abuse of African Americans throughout the South, not just in Wilmington, but throughout the South, the elevation of white supremacy accompanying the Supreme Court's decision. Red Summer of 1919, where more African Americans were lynched and there were more race riots, often prompted by false accusations and tropes directed against the African American population, including the effect of Birth of a Nation in shaping public attitudes at that time. And the Tulsa, Oklahoma massacre of 1921, again, which will be acknowledged next year. Just those examples alone make clear that we have an entitlement to a review of our circumstance in this country, particularly based on the principles of equity that we've talked about. So let me give you a couple of examples of why I am so optimistic that the campaign for reparations on behalf of African Americans will ultimately be successful. As I mentioned, one of my earliest efforts as an attorney was with the ACLU, supporting the passage of the Civil Liberties Act of 1988, also known as the Japanese American Redress Bill. It is Public Law 100-383. That statute has provided the framework through which to review the African American experience because it is a congressional precedent that began with the idea generated in 1970 by the Japanese American Citizens League, one of the founding 35 organizations of the Leadership Conference in 1950, I should say. But the Japanese American Citizens League, through its grassroots efforts, helped to propel Congress to take a look at these issues. And it established a commission to examine whether, in fact, reparations was owed to the Japanese American citizens community that had been interned during World War II as a result of Executive Order 9066, signed by Franklin Roosevelt. And the commission was established to look at that issue. Secondly, it established an apology for the injustice that occurred. Thirdly, it created a public education fund to finance the reform and to understand so that it would prevent a recurrence of that problem. It also made direct restitution to Japanese Americans who were interned during World War II, who lost property, and who could establish by virtue of their internment that they were entitled to a reparation. It was approximately $20,000 in 1988 terms, which is about $40,000 in today's terms. It also addressed the treatment of the Aleut Islanders, the Alaska Natives, who were caught up and interned during World War II. I should note it did not, however, apply to Japanese citizens of other countries who were also swept up during the internment, particularly fishermen from Peru, who were captured to be used as trade bait by the American military and taken into internment camps in the United States. Subsequently, after the bill went into effect, they were able to claim an equal injustice, but they were compensated substantially less with a $5,000 payment.
Right,
But
I'm just, as a moderator, it's the worst job, and because I could listen to you for the whole afternoon, but if you have last, we can return to some of these examples a bit later.
So I'm going to wrap it up by saying two things very quickly. First, the Japanese redress bill has, among other of its clauses, a provision which says to make more credible and sincere any declaration of concern by the United States over the violation of human rights committed by other nations. And then just to sort of wrap this up very quickly, there is also the Congressional Apology for Slavery, HRes 194, which was adopted in 2007 and 2008. And I can provide language for those who want it, but there were two things that were significant there. First, on July 8th, 2003, during a trip to Gorée Island, Senegal, a former slave port, President George W. Bush acknowledged slavery's continuing legacy in American life and the need to confront that legacy when he stated that slavery, quote, was one of the greatest crimes of history. The racial bigotry fed by slavery did not end with slavery or with segregation. And many of the issues that still trouble America have been directly related to that experience. And in conclusion, there is a be it resolved clause, which of course captures many of the statements that were adopted at the time, but it has one effort that is particularly important, obviously the apology and acknowledgement. It expresses its commitment to rectify the lingering consequences and misdeeds committed against African Americans under slavery and Jim Crow, and to stop the occurrence of human rights violations in the future. Those provisions have been adopted by Congress. They lay a foundation for what we propose to do regarding the HR 40, the Reparations Commission Bill. And it builds on the understanding of the imbalance that exists today because of the COVID-19 example is just a graphic depiction of inequality writ large. And that will be the basis for pursuing these efforts going forward. Thanks so much, Nadia, and sorry to run over.
Not at all. Thank you so much. That was excellent. And thrilled to think a bit more with you about that. I'm so grateful that you brought up the pandemic and particularly the racial disparities and trying to, again, as we're saying, it unveils the reality and again, the necessity of reparations and of historical injustice. So we're going to turn to Justin Hansford. And I think a lot of your work, Justin, inspired the whole of the CLE. So on that note, for those who are here for the CLE, and just to note that there are over 300 people who have registered for the CLE, which is extraordinary, but your course code is HR 2020. HR 2020 for those who are joining for the CLE. And as I was saying, Justin, in 2015, you wrote a law review article with one of our comrades, Mina Jagannath Ferguson, to Geneva, using the human rights framework to push forward a vision for racial justice in the US after Ferguson. So interested to hear from you about how you have used the human rights framework, lessons learned at the UN, the Inter-American Commission. Take it away, Justin. Thank you.
Sure. Well, thanks for having me. And I'm very excited about this meeting. I've already learned a great deal from Wade and from Ruben and from Margaret and all the wonderful speakers. From our perspective here, I'm at Howard University. I am the director of our Thurgood Marshall Civil Rights Center. But of course, we understand that the Constitution has never been enough for us to be able to create the world that we want to live in. Justice requires a great deal more than the Constitution allows for. I'm going to go into more detail about that later on, but our goal is to obtain racial justice using a human rights framework and a social movement-centered approach. What I want to discuss today is how we've thought to try to use these international human rights mechanisms while continuing to privilege the leadership of organizers, and also incorporating theory and scholarship and all of the cutting edge thinking on these important issues specifically relating to reparations, and my experience over the course of the past couple of years. I actually want to start out with a hearing that took place, and I'm going to share my screen very briefly here. A hearing that took place this past October in conjunction with the United Nations on the subject of reparations in New York, organized by the Special Rapporteur on Racism, who prior to the hearing, and I can provide links to these websites later on, prior to the hearing, the Special Rapporteur published principal guidelines for a comprehensive reparations policy. And this experience did a great deal to shift my understanding of how reparations is operationalized in a global context through a global lens. And from a theoretical standpoint, it was a reorienting experience for me. Specifically, I want to go down here to point 10 of this document, where the Special Rapporteur describes how the historical use of the law to evade accountability for reparations has, here's the document I'm looking for. Historically, the Special Rapporteur was outlining how international legal doctrine has a longer history of justifying and enabling colonial domination than it does of guaranteeing equal rights to all human beings in the international space. And internationally, and here's the Special Rapporteur's document at its heading. Historically, international law has been used as an obstacle to obtaining the goal of decolonization. And similarly, if we were to think in similar terms to the goal of eradicating racism in the United States, constitutional law has been more of an obstacle than an aid in that process. Why was this important to me? Because so often as attorneys, when we start to think about the question of reparations, the first thing we think about would be the problems with reparations. What are all the problems from a tort law perspective? What are all the problems from the perspective of the statute of limitations? What are all the problems from the perspective of determining exact remedies that are accurate and that would be upheld by a court of law? What are all the legal obstacles in our way? And what this discussion outlined to me was the fact that the law is an obstacle only for political reasons right now. And with sufficient political will, the law can be reformed to be a support. If not on the federal level, then on the state and local level. We should enlarge our imagination and look at our tools that are available to us as advocates, and perhaps shifting the law so that it no longer becomes an obstacle in the first place. And so another point that was made here in this document that was promulgated by the Special Rapporteur is the international structure and the international guidelines on reparations that can be found in point number 37 here on page 34 of this document. And so this structure, I believe, is the type of structure that can provide guidance for congressional initiatives It can provide guidance for state and local initiatives. It can provide guidance for non-state driven initiatives, working with your local church organization. We know that reparations efforts over the course of the past year have been perhaps most successful at places like the Princeton Theological Seminary, which dedicated about $10 million to reparations, the Virginia Theological Seminary, which dedicated over $2 million to reparations, the Reformed Judaism organization, which also has committed itself to reparations. Are those reparations going to be guided by the 5 norms set out in the international human rights context? Restitution, compensation, rehabilitation, satisfaction, and guarantees of non-repetition. And how have these different principles been useful in historical contexts? Another thing that I think that I gained from Ruben's presentation, when we look at all of these other examples around the world, when we look at different frameworks that can be used, have we yet done a very internationally organized analysis of where those efforts came up short and where those efforts were helpful? And now that we have this global lens, are we going to take the next step of getting engaged in an analysis of what these different structures can teach us from a reparations perspective? So third, I just wanted to speak about the overall approach that the Special Rapporteur took. It comes from the tradition of scholarship called the Third World Approach to International Law. It goes by the acronym TWAIL, which I found to be very interesting as a critical race theory scholar. As you know, critical race theory is an approach to legal scholarship that focuses on how law in the United States context has been used as a tool to promote racial hierarchy. And thinking about in the international context, what can we learn from the reality that internationally, in spite of the success stories that we've seen on reparations in some cases, overall international law has been used as a tool to support colonialism for most of our history. And in the same way that the law in the United States historically upheld racial hierarchy and still does so today, even post-slavery. In the same way, even though colonialism is no longer the rule of the day, we are in what we call a neo-colonial context in the international legal sphere. So in the same way that there are new legal concepts that scholars have looked at, like the concept of odious debt, to argue that places like from Palestine to South Africa should not, from a legal perspective, be submitted to further economic oppression because of legal norms that were designed to create oppression. How do we rethink the law in the United States so that things like statutes of limitations and other legal fictions do not become technical rules that are privileged over human rights? And so from a legal perspective, I think about that very often, even going to our own Supreme Court. We know that Justice Scalia and other prominent justices have articulated opposition to principles like affirmative action. Very thinly veiled statements, such as a case called the Richmond versus the City of Crossan, where there has been this fear of vengeful dominance on behalf of those arguing for affirmative action, which would be a fear of retributive justice, going back to Margaret's point, a fear that in light of all the sins of the past, there would be some sort of retribution that would take place through affirmative action or reparations. And for that reason, seeking to enforce this colorblind norm of simply evading all attempts for accountability. As opposed to thinking retributively, if we do think in a more restorative justice framework, then perhaps we might see less fear of reparations or affirmative action or other efforts to create justice and human rights on the grounds of fear of retribution. And so one final point I want to make on that, Wade very expertly discussed Section 5 of the 14th Amendment, which historically has limited the ability to promote anti-discrimination to state action, and has also been, along with our standing rules and constitutional jurisprudence, limited to individualized harms. These legal norms, I argue, again, should not be seen as limits to our advocacy, but should be seen as obstacles that the onus is on us to overcome. We cannot pursue an individualized approach to reparations. It has to be collectivized and structural. We do not have to limit our arguments for reparations to state action. We know that organizations as varied as corporations and churches and private individuals. I'm a descendant of people enslaved here in the United States, and I recently was added on Facebook by someone with my same last name from the small town where the plantation was, where my family originated, and we are perhaps going to be in communication soon. Someone who's not African American. So that type of state-based remedy lens is another lens that we can discard once we begin to think larger and think global and think outside of the norms that were implemented to limit our access to justice. So I learned a great deal from a theoretical perspective, and I know I'm running short on time, but I also wanted to speak a bit about some of the practical outcomes of the advocacy that we were able to engage ourselves in. So in addition to working with the United Nations, we also worked with the Inter-American Commission. The first document here I presented to you is actually from the Organization of American States. And this was it's an internal guideline statement that they sent out specifically focusing on reparations projects in Colombia, which, as I have articulated in the past, and has Ruben articulated as well, were an inspiration for using the Inter-American Commission as perhaps a jumping off point for more advocacy locally here in the United States or nationally. In order to have this discussion at the Inter-American Commission, we had a request for a thematic hearing that was granted by the Inter-American Commission, signed on by 29 co-sponsoring organizations. Included amongst those was the Leadership Conference on Civil and Human Rights, along with many others. And this type of solidarity was what was necessary to get a response from this huge organ. And if I wanted to have a huge takeaway, just in the same way that the Reparations Project, just again to respond to Margaret's statement that was so interesting to me, we know that we have to approach the project from a perspective of solidarity. Solidarity is going to be what moves us forward. Margaret spoke to how one of the Afro-pessimists' critique of reparations was that it will be seen as some sort of final solution or ultimate solution to all the problems of racism. But instead, we should see reparations as an opportunity for solidarity, and ultimately from a societal standpoint, as my niece yelling, from a societal standpoint, it should be seen as a statement of solidarity that we can make to move forward on making up for past wrongs. It will not be a solution. It will be a statement of solidarity, and it should be obtained through solidarity, not just legal advocacy, not just scholarship, but also organizing. And that organizing has to take place with people who are grassroots organizers, but also organizing amongst advocates. so that we work as a collective. And so that, I do want to end on that note. I think that going forward, to use mechanisms such as the Inter-American Commission, again, we would need to once again move forward in solidarity. I will even issue a call if you are in any sort of relationship with any groups that have successfully obtained reparations in different nations or in different cities, and they would like to continue to work with us on reparations projects, please feel free to reach out. And we are currently exploring new avenues to be successful in this work. One of the things that, cutting down.
One last word.
One last word. Okay. One of the things I was saying is that we always want to use our head, our hands, and our heart when we're doing this work. So it's not just scholarship. It's not just getting our hands dirty in terms of litigation, but also using our heart and connecting with the people. And so I hope that we can continue to connect on this work and we can, in that way, obtain victory.
I'm so glad I let you have that last word. Amen. Absolutely. And spoken as a true movement lawyer. So appreciate you so much, Justin, for that. We're going to turn to Monifa Bendele, who is going to talk to us a bit about the exceptional work of the Movement for Black Lives, who again released the reparations toolkit last summer. And so this is operationalizing the human rights framework. And we want to hear a little bit more about the aims and objectives. Why now? What are your hopes for the toolkit moving forward? Monifa, so happy that you're here and sharing your screen already. Let's go.
Much. I'm going to jump right to it because I know that we're short on time. And I just wanted to really talk about how the call for reparations is being operationalized on the local, state, and federal level by Black organizations. So the Movement for Black Lives is more than 100 Black-led and Black-centered organizations. And we are fighting on every level of government, every level of society in America to promote reparations. And so one of the things that we always do in this work, of course, is first acknowledge the people who've done this work before us. So the Movement for Black Lives really builds a lot on the work of historic organizations like NCOBRA, who've been fighting for reparations in the United States since the 1980s. And also on the excellent scholarship of NARC, which is the National African American Commission on Reparations. As part of our work, we make sure that we are basically on the same page on reparations. You know, it became a really popular call and popular phrase and caused a lot of divisions throughout the communities, I think because we aren't speaking loud enough and consistent enough about what it is we want and what it is we mean when we say reparations. So just to give a little context for the Movement for Black Lives, we believe that all descendants of enslaved Africans in the United States are owed reparations for the devastating harms of colonialism and of the transatlantic slave trade. The institution of chattel slavery, reparations must include full compensation for stolen lives, labor, children, health, well-being, sexual and gender reproductive autonomy, culture, language, spirituality, and for torture, rape, and other forms of physical and sexual violence flowing from the institution of chattel slavery. But these harms were not only perpetuated and sanctioned by the United States government and slaveholding families, but also corporations, educational institutions, religious institutions, philanthropic institutions, and they continue to profit off of the labor, bodies, and lives of Black people even to this day. We also really push that reparations must take as many forms necessary to equitably address the multiple injuries caused by the transatlantic slave trade and chattel slavery. But reparations isn't only about the incident of slavery, which was mentioned earlier, and the terror inflicted on our people, now ancestors. Slavery has a brutal afterlife. For example, one of the things I'm going to talk about today is that between 1971 and 1992, Chicago Police Commander John Burge and detectives under his command tortured more than 120 Black men and women during interrogations. Detectives used electric shocks, suffocations, beatings, Russian roulette, rape, and denial of food, water to obtain confessions, which were then used to secure criminal convictions, severe sentences, up to and including the death penalty. And I'm going to flip my slide real quick. And so some of the, sorry. So these torture, so this state-sanctioned violence and police torture, segregation, and the racial terror of Jim Crow era, housing discrimination and redlining, and the ongoing effects of racial segregation, discrimination, and structural exclusion, which represent ongoing impacts and harms of slavery, have not ceased or been remedied. And we know from earlier, one of the key components of reparations under the human rights framework is secession, means that it has to stop. What's happening has to stop, right? And that hasn't happened in any of these cases. We also recognize, and this is very important, and we underscore this in all of our work, that anti-Black immigration policies and practices and the harms flowing from them are both rooted in slavery and part of the ongoing afterlives of slavery. The practice of chattel slavery in the United States marked all Black people, regardless of whether they are direct descendants of African enslaved in the United States, for dehumanization, violence, structural exclusion, and discrimination. So we call for reparations for all Black people in the United States who've been subjected to post-slavery policies and practices representing the continuation of harm. So what happened in Chicago? Torture survivors, their mothers, their families, organizers, reporters, lawyers, led a 30-year struggle. And as a result, they won Burgess' termination from the police department, an official acknowledgement of systemic practice of torture, and the exoneration, though, of only 31 of Burgess' torture survivors who were subsequently released from death row and prison. Some survivors were able to file successful civil rights or wrongful convictions and obtain financial compensation. However, many survivors could not successfully file lawsuits because the statute of limitation had passed. So fast forward though to 2015, one of the things I know I was asked to talk about was just an example of community organizers coming together and winning some form of reparations. So in 2015, the city of Chicago signed into law an ordinance granting $5.5 million in cash payments, free college education, priority for city employment, and a range of social services, including the creation of healing and organizing centers in the South Side of Chicago to the 57 living survivors of police torture. Explicitly defined as reparations, which is key in any form of reparations, the ordinance includes a formal apology from Mayor Rahm Emanuel and mandates that the incident be taught in public education throughout the Chicago school system. It's important to point out, though, that of the dozens of police officers and people who participated in the torture and the prosecutors who used the confessions that were gained for those torture, only one person was ultimately brought to any level of accountability, which was Burgess. In fact, many of the police officers and prosecutors who participated in this torture incident, if we bracket it, went on to become elected officials, and even one became the mayor of Chicago. So I think it's important to, I'm gonna stop sharing my screen, to look at how this movement is building on the ground. Cases like Chicago, organizing that happened at Georgetown University, North Carolina around sterilization. And so we see a movement that's both fighting on the national level to have conversations and to have policies passed, but are also using local organizing as the building blocks for reparations movement. Both of those things have to happen. I'm glad you gave a hat tip that Justin is a movement lawyer. And so the coming together of all of the different sectors of our movement to both have an organizing strategy, a communication strategy, a legislative strategy, which Wade talked about, and a litigation strategy, which are building all over the country, is the way that we're going to be able to eventually see some remedies for Africans in America.
Thank you so much, Monifa. I'm just going to ask you to return to that last sentence where you laid it out. What do we need? You know, you have a litigation strategy. Can you say that one more time? I think we need to hear it again.
Well, I'm gonna start that we have to have an organizing strategy, right? And that's why I acknowledge the activists and who really build the will for the conversation. You can't step into a congressional hearing. You can't step into the courtroom and just pull a concept out of some textbooks or even out of an international context, which is really important. There has to be will on the ground. People have to want it. People have to be talking about it. People have to be demanding it. So there has to be an organizing strategy. So you have a communication strategy too. And that's one of the things that we realized we had to get very coordinated around, because people wanted to leave certain members of our community out of reparations. So we had to come together and say, no, this is who's owed reparations, and we're including all Black people. And so your communication strategy has to be tight. The legislative strategy, which Wade outlined, you know, the work that's been going on in Congress and being reflected in state houses all over the country. And then litigation, you know, we ultimately will have to sue based on a plethora of campaigns that were designed to oppress Black people, like the drug laws, like the war on drugs, as it was called, and pull those things apart and sue the United States on those practices. So all those things have to come together. There's no silver bullet. And that's why I think this panel reflects both the international, national, and local organizing.
Thank you so much, Monifa. If you've seen it before, it's organizing, communications, legislation, litigation together, right? That's it. That's where the power is when we're organizing together. So we are nearing the end of our panel. We have about 7 minutes left. I just want to reiterate that there's a CLE code, HR 2020, for those who are here for the CLE. What an extraordinary CLE. This is the kind that we need lawyers to be engaged in, to be thinking strategically about social change and social transformation, particularly in the context and the concepts of reparations and repair. And we're going to move into a transformative space in the next panel, so excited for you all to stick around for that. HR 2020. And we have just a few more minutes, and I want to give each panelist an opportunity to address one more piece of advice for, you have, again, over 300 people who are listening now, who are looking for tools, who are looking for the ways that they can improve their legal work on behalf of social movements. And you have organizers and you have advocates who are listening to you. So, you know, as we go and set off in the next direction of transformative justice and restorative justice, let us return to you, Ruben, a bit, you know, in terms of implementation. You've seen it done across the world. If you could give us one more insight into how we can make human rights and reparations real, that would be really useful. So one more example or one more nugget of wisdom, Ruben, thank you.
Well, I don't know if it's wisdom, but perhaps just a lesson. Many of the reparations programs that have been implemented were implemented because people who wanted reparations, who sought justice, took power. So it's power, not law, not technical capacity, that really determines whether reparations get implemented. And by power, perhaps it should also be clear that in the United States, simply having an African-American president does not mean power. And so what that means perhaps was you had an opportunity to discuss reparations, and that's what some of the panelists have pointed out. But power means more than just having someone who represents, you know, the color of your skin or some of the history that you share. And this goes into a larger part of the debate over incremental and revolutionary. And I think some of the ideological questions that need to be answered also need to be answered by advocates of reparations for racial justice in the United States. Is it premised on power in terms of racial identity, or is it going to be premised in terms of an ideological agenda that prioritizes reparations? And if it's reparations, what do you mean? What do we mean exactly by that? And so, just as a last point, I think it's also important to look at comparative examples, because they do give you lessons about how to pursue power, perhaps not completely, perhaps incrementally. The example I gave about Kenya and the Mau Mau veterans suing the United Kingdom in a United Kingdom court to obtain reparations may not mean much in terms of changing colonial relations, but it also meant that they forced the United Kingdom not only to acknowledge colonial torture, but to build a monument and fund it, and to show up in Nairobi at the opening of that monument and to say, look, we acknowledge that in this exercise of power, the colonizer lost. So that's one lesson to learn.
Thank you so much, Ruben. Yes, acknowledgement and as a step towards repair. And so to you, Wade, as you're in this, one of the strands of work that Monifa mentioned in the legislative work, HR 40, is there a way that others, one, can get involved and support that effort, and two, it's one piece of the struggle. Is it enough? How do you answer some of that, the questions that also Ruben posed and others are asking?
So Nadia, thank you. I want to make 3 quick points and I'll be finished. First, next week, Representative Barbara Lee will introduce a resolution in the House of Representatives dealing with the issues of truth, racial healing, and reconciliation. This as an important down payment on the discussion that will ultimately engulf the Commission on Reparations that HR 40 calls for. And the Leadership Conference will be supporting Congresswoman Lee's initiative. That's number 1. Number 2, Monifa's analysis was spot on. And organizing is such a critical component of our ability to get Congress to take issue with the kinds of things we've talked about in the context of reparations. But in that context, elections matter. It is critically important that there be a recognition of the importance of federal and state elections, and that those who support a Commission on Reparations and ultimately the adoption of HR 40 must understand that if we have a chance of passing that initiative, it's because we have influenced Congress by virtue of the November election, and it's important that we all vote and not be affected by the efforts to suppress the vote, which we know are going to be rampant. And then thirdly, courts matter. Keep an eye on what Mitch McConnell has done in packing the federal courts with a conservative judiciary that will be unwilling to recognize the foundational, constitutional foundational predicate for reparations. So it's important that we stop the appointment of these judges as quickly as possible, and certainly recognizing that within the next 6 months of the election, there should be no further efforts to appoint judges until after the November elections, and that has to be a mantra that we pursue collectively. So those are my 3 quick observations, Nadia.
Thank you, Wade. Thank you, Wade. Let's get to the win. Let's protect the wins, absolutely. Justin, you spoke a lot about solidarity. You spoke a lot about agency. Is there a particular concept in human rights that you would say is kind of foundational to bringing into social advocacy efforts in the US, where you say this is something that you really should study? You can lead us as a professor to more work, for sure. I see you putting that in the chat. And so if you have insight that you can offer. Professor Hansford, you're muted.
Okay, and now I'm off mute. So thanks again. And also as the professor, I just wanted to make one edit, Nadia, to the 4 points you mentioned. The 5th point, which could be your thumb, is scholarship and research, as well as organizing, as well as advocating in the courts and on policy. And so for me, I think about critical race theory, which is what helped me to understand the opposition to reparations, at least how it has been acknowledged by those in the courts and those who have tried to, in different venues, make arguments against its feasibility or against its practicality. And to be clear, there are different takes on reparations in the scholarship. Alfred Brophy is a longtime reparations scholar who I could recommend for people. Recently, there was a book released by Sandy Darity out of Chicago, which is a book that I have not read the book yet, so I can't do its quality, but it's definitely a book that's going to be something we're going to be discussing in this field for many years to come. And of course, 12 Third World Approaches to International Law. I think that also is important. The last point I would make, and from the theoretical perspective, the leap for me was moving from a civil rights perspective to not just a human rights perspective, but a perspective of how do we decolonize? How do we move past the local anti-racist perspective to a perspective of anti-colonization? How do we see ourselves as a part of a global movement? How do we see ourselves as part of a push for not just equality, but a push for self-determination? And for me, when I think about the decolonial move, that's a self-determination move. It's a move that is also focusing on economics, not just legal equality from a political rights perspective, but also keeping in our minds and in the front of our consciousness that this is an ongoing struggle that's global and that has some very fundamental principles that we want to ensure to incorporate.
Excellent, Justin, thank you so much. Absolutely, and it brings us back to also what Ruben is saying, listen and learn from comparative examples. You're gonna have a lot of materials that I know Joanna is offering or that you'll have in your packets with more of the tools from our panelists. Munifa, I wanna give you the last word in terms of how we can start making this a reality. And again, building on Justin's advice around internationalism, Movement for Black Lives is explicitly internationalist. What does that mean, and how do you learn from each other and build globally towards collective liberation?
There's an important lesson that we learned recently from this COVID-19 crisis, which I'm glad that was raised by Wade, which is that we have to collectively stop operating from a scarcity mindset. In a matter of 10 days, a Congress that's been deadlocked for 4 years, hasn't really been able to pass anything, was able to cough up $3 trillion with a T dollars. And I found that in our organizing and in our campaigns, we're always working from this idea of scarcity. You know, it's almost like it's one of those vestiges of slavery, I actually believe, you know, that, oh, there's not enough. We can never get this. It's not there. We have to completely wipe that out. We have to look at what is needed for the remedies and fight for that. Stop operating from scarcity. And then the final thing I want to say to the students is that I hope that you are fired up by today. I hope that that fire encourages you to build a campaign around reparations. But if you ever go into a room in a campaign to build around human rights and reparations, and there are not organizers or public policy advocates in that room central to that discussion, shut it down. Start over, because your wins will be limited. We have to have all of these levers of organizing, and we have to dream big and stop thinking from such a level of scarcity.
What an incredible note to end on. Thank you so much to all of the panelists. Thank you, Munifa, for those words. It's an honor. It was an honor to moderate and to learn from you all. I have tons of notes as well. And we'll share all of those slides and, again, resources. Thank you so much to you all. And back to you, Joanne.
I have the worst job in the world, which is cutting off what has been such a rich discussion about how to build power, how to push boundaries, how to overcome the barriers that the law presents to us, and how we need to do that in coalition with expertise from all different fields. Lawyers can play a small role sometimes, but it's really working in concert with organizers, scholars, and very many people like you that we can make this happen. So I am committed to continue these conversations in another space and another time, and I hope all of you will join me. For now, we're just going to take a 5-minute break before we launch into the second panel, which will move more to the local and focus on restorative justice initiatives. Thank you very much all for your great insights.